Good day, Vainath Yun, and I'm talking to you from Alpha Human Resources Management. We are a HR company based in the Western Cape in South Africa. And in this session, I would like to discuss the situation with regards to employment contracts. And I know there are people that think that this is not necessary. It's not necessary to have a written contract with an employee. I unfortunately beg to differ from it because I believe that if you've got something in writing, it's got more of a standing than when you verbally agree with somebody about something, and then afterwards it's a question of somebody disagrees with what was said and so forth, So as far as that is concerned, I am one of those that are much in favor of a written employment contract. And nowadays, it's important that the contents of that contract is absolutely correct and describes what is expected from the two parties, the employee on the one side and the employer on the other side. Now, when it comes to contracts, we've got quite a variety that we supply to our clients. And it starts off obviously with your contract for a permanent employee that works 52 weeks a year, almost like or being employed for that period and so forth on a regular basis. And it's got a starting date, but there is no sort of end date to it unless you in your contract describes the date of retirement and so forth, which is very essential. The second type of contract that we've got is a periodic one, which is not that, the knowledge about that one is not that good, and it's not everybody that knows about it. But why it's called periodic is because it's written for specific employees that work for a period of time and then they get laid off for a time and so forth. And the benefits only kicks in. It's a once-off contract, once again, so it's a semi-permanent contract. But it's based on that variety of work that might pop up and the essentiality of having those people to work for you. And then they get a period that they get laid off due to the fact that there's no work whatsoever. The third one that we're talking about is the so-called fixed term contract. And this is one of the contracts that you've got to be very careful about, and I know there's a lot of abuse, can I almost say, with regards to a fixed term contract and so forth. And where it's often abused, it's when it is used as to cover for a probation period, which is absolutely illegal. You can't put a person on a fixed term contract and say, well, that fixed term contract applies for the period that the person is on probation. And the norm that these people use is usually 3 months. Now, that kind of fixed-term contract is absolutely illegal. Where it becomes more legal is when you know that a specific position is only open for a fixed period. And that is, say, for instance, when your secretary or somebody within your company goes on maternity leave, you know exactly when that person is going to go on maternity leave and when she's going to return. Now, in that case, if you bring in somebody for that period, that I would say is the correct method of making use of a fixed contract. For the others, there is doubt in my mind that it's actually used legally correctly. The next one that comes in is one that we've actually started a couple of years ago, which is called a fixed task contract. It's very popular in agriculture because agriculture has got these various seasons, various needs. And what it actually means is that the person comes in and operates for a period, and the contract is sort of running until that specific task comes to an end. And once the task comes to an end, the contract also comes to an end. And it's nowadays very popular where we operate, especially, as I said, in the agriculture business, where it's very much applicable and so forth. Okay. Next one that we're talking about is what we call the project contract. And say, for instance, you've got a specific project that you want to implement in your company, or if you've got a new position that's never been there before, and you put that new position, that new idea on a project, and you appoint maybe a project manager, for instance, and that kind of contract can also then sort of run until the end of the project, which is allowed. So, but you must specifically then mention or call the contract a project contract. Next one that's important is very important if you're making use of the so-called TESs, that is the temporary employment services that we've got. And there we've got two types of employment services. The one is what we call contractors. Now, when it's a contractor, the contractor would come in, bring his own staff, and come and do a specific task for you in your business. And once the task is finished, then of course he withdraws with his employees. He's totally responsible for his own employees, but there must be something in writing between the business and the contractor. And the other one is what we call the labor broker, not a very popular one, especially amongst the unions. And and also I am not much in favor personally with a labor broker's contract, but nevertheless, they are there and they are very helpful in certain businesses. What happens there is that the TES, that is the temporary employment services, they supply workers for you. It's not that they are bringing in like a contractor, bringing in their own team, which they decide on the size, they decide on who's doing what and so forth. What they do here is they supply you with employees, individuals, for certain tasks and so forth. So they're still reliable, or let me say liable for that individual or individuals, but you are co-liable for what's going on. And it's one of those contracts that you've got to make very, very sure that the wording is 100% what you expect of that labor broker and the employees and so forth. And usually what often happens is that those individuals go onto the payroll of the company, where with a contractor, it doesn't happen. But with a labor broker, they go onto the payroll, and you are taking responsibility for leave and sick leave and everything that goes with that. That doesn't exist in the contract that you've got with a contractor. So just make sure about that. Now, the Act is also very clear with regards to what must appear in those agreements or those contracts. So the fact that the Act per se doesn't talk about a written contract, it doesn't mean that you cannot do without something in writing that is presented to the employee that tells him what the relationship is like and what's going on whilst employed by the company. And the important things that the Act highlights, and I'm adding a couple of things to it, is first of all, in the contract, the name of the employer must appear there. Secondly, obviously, the contact details of that employer. And then, very important, number two, the name of the employee. And with that, we prefer to also fill in the ID of the employee. And if you've got it, then even the residential address of the employee is in that contract and so forth. Obviously, the one that's very important is the position itself, the job title. What is the employee or the person being employed for? And along with that, you can add a task list. I don't like putting the tasks within the contract itself. I usually add an addendum to the contract, which is the task list. Some people call it the job description. I prefer the wording task list, that you do that. So that is important that you've got there. Then next, that you've got to talk about the salary, obviously, or the wage that you're going to pay the individual, and you're going to also put in there how does overtime work and what's the payment with regards to overtime, especially when it comes to public holidays and when it comes to Sundays and things like that. It is prescribed in the Act, and it differs from industry to industry, so one's going to make sure what the Act or what the bargaining council, whatever, says about overtime and how is it getting paid and so forth. Working hours, of course, is essential, and the working hours differ from business to business, industry to industry. In South Africa, the maximum working hours is 9 hours a day, or 45 hours in a normal week. And if I talk about a normal week, I'm talking about from, say, Monday to Friday, but it can also be from Monday to Saturday. Then your daily hours then obviously differ. So it's 9 hours from Monday to Friday, it's 8 hours from Monday to Saturday, and everything that goes with that. You would also, in your contract, you would add on any possibility with regards to any bonuses, if any, or profit sharing, whatever. That will also be described in the employment contract and so forth. Then the next one, that is the necessary deductions that needs to be made. There's certain taxes that's got to be deducted, and there's UIF and so forth. So you've got to make sure that people understand that the statutory deductions got to be done. But if there's any other deduction, it must be described. And if the situation is outside statutory deductions, then obviously you've got to make sure that the employee gives you permission for those extra deductions that is not statutory. All right. The next one is if there's any benefits that the company offers, and here we talk about medical benefits, you're talking about certain allowances, being it a car allowance, housing allowance, cell phone allowances, medical aids, pension, provident fund, things like that. Now, anything with that regard must appear in that contract then, obviously, as well, which is very important, and so forth. Then you must, within your contract, you must refer to your company's policies and procedures. You don't need to spell them all out, because that's going to make the contract too big and too a wastage of a lot of paper, whilst you've got your contracts maybe in another form. But the employee must be made aware of the variety of contracts that is available and applicable to them as an employee. Very important lately is in South Africa is the POPI Act, and the company's got to have a POPI policy, and it must be stated in the contract of employment that there is this policy, which is very important. More important than that is the COVID-19 policy of the company, and it must be explained to the employee exactly how is COVID treated within the framework of the company itself. Okay, we spoke about the hours of work. It's important that you talk about the overtime, how is it getting paid. Some people make the mistake to say that overtime only kicks in once you've completed your 40 hours for the week or the 45 hours for the week, which is not true. Overtime is actually paid on the daily overtime that occurs within that company. There is, of course, the whole question about leave. How much leave is the person entitled to? That's explained. And then sick leave, family responsibility leave, the new parental leave, and so forth. So all those, study leave even, all those things must be explained in that contract and be in writing, black on white, so that there's no sort of confusion with regards to what an employee is entitled to. It must be remembered, however, that there is a threshold with regards to certain things, and that threshold at the moment is 211,596 rand and 30 cents per annum. That's around about 17,633 rand and 3 cents per month. Now, once you are over that threshold, then certain things doesn't apply to you, like working hours, like meal times, like certain overtime and so forth, so you've got to make sure whether this employee is under or above the threshold in South Africa and so forth. And then very important is the use of company equipment, be it a computer, be it a cell phone that has been given to the employee to operate, be it whatever, the car, the computers, I said, and the usage of the computers for private use, is it allowed or is it not allowed? And one's going to be very careful that you actually stipulate that and make sure that the person understands what it's all about. Then the private information of the company, that there is a restriction. You can't just go about and talk to anybody or everybody about the policies of the company or the so-called secrets within the company. Make sure that you understand that and make sure that people understand exactly how it operates. Right. Then the whole thing about kickbacks and gifts, it often happens that people in the execution of their tasks, the clients actually give them something, and you've got to have clarity as far as that is concerned as well, that it must be disclosed, it must be maybe written in a book or something, and you make sure that that is also highlighted in your contract of employment. And so make sure that all these things, and it depends very much on the company itself and the infrastructure of the company and what is needed. Now, we assist with that. So if you need any help with regards to contracts, don't hesitate to contact us. Our information will be below, and we can assist you and make sure that your contracts are 100% in line with the legal requests or the demands of the labor law. It is shocking often to see certain contracts from certain companies that it's not updated and that the people do not realize that that contract is actually illegal and that you cannot expect of people to sign the contract. And that brings me to that question. Can you force anyone to sign a contract? No, you can't. If they don't want to sign it, all you do is just write at the bottom, refuse to sign. Okay, is the contract unsigned still applicable to that employee? Yeah, if the contract is legally correct, there's nothing that stops you from telling the employee whether you signed this contract, yes or no. It will be applicable to you. If you have any questions, please do not hesitate to make contact with us, and we will certainly see how we can assist you and help you and make sure that your contracts are in place, that your contracts are legal, and that your contracts are a working document and not sort of a situation or creates a situation that there is not clarity about what is expected from the two parties. Thank you very much for your time, and we'll see you again.